Good evening and greetings. Good evening and greetings. My name is Bill Fletcher. It's my honor to be with you this evening to join us in this discussion about the ongoing conflict in the Western Sahara. This evening is sponsored once again by the campaign to end the Moroccan occupation of the Western Sahara, along with the partnership with the Institute for the Black World 21st Century and the Pan-African Unity Dialogue. This is the second in our webinars, and we're really pleased that you're joining us in this evening's program. So in our first program, we looked at the background to the conflict, trying to understand the history of it. Tonight, we're going to have the opportunity to look at legal issues, in particular the issue of international law and this conflict. And we have the opportunity and the honor of having with us two individuals and possibly a third. We're hoping that he will join us, who will look at this. We have Sheha Abdullahi, who is a Sahrawi human rights activist and a speaker on the cause of the Sahrawi people, and she's a founder of the Bridge Generation Libraries for Refugee Women. And we want to welcome you to the program. We also have the honor of Pedro Pinto Leite, who is a Portuguese-Dutch international jurist and former attorney with a master's in international law from Leiden University. He has been the secretary of the International Platform of Jurists for East Timor since 1991. And I want to welcome him as well. Thank you for joining us. So I want to begin, and the format this evening, I'm going to ask a question first to each of the panelists, and then I have a series of questions that anybody can answer, and we'll have a discussion, it'll be a dialogue, like in a kitchen discussion. So Pedro, I want to start with you. In our first episode, we talked about the Moroccan invasion of the Western Sahara, and people can respond to that morally, i.e. that it was an immoral act on the part of the Moroccan government. But from the standpoint of international law, can you explain to us how was this a violation of international law? And actually, without sounding cynical, what difference does it make whether it was a violation of international law or not?
Well, it was a violation of international law, and a terrible violation. When in '86 I was preparing my thesis on East Timor at the University of Leiden, I asked, I gave my thesis, or a part of it, to Professor Peter Koymans, was my thesis director. And his reaction was very curious, because he said to me, "It's clear you are a lawyer. Your thesis looks more like an indictment of the legal representative of a crimes victim." And I retorted that I couldn't get away from it. I had only found one issue on which jurists were divided, on which the arguments for and against could be weighted. It was whether when East Timor was invaded, it was already a state or just a non-self-governing territory. Everything else was crystal clear, a huge amount of violations of international law by Indonesia. And the same is true here in the case of Morocco and Western Sahara. It's not by chance, by the way, that the title of my thesis was Oost Timor, the Westelijk Sahara van Zuidoost Azië, or East Timor, the Western Sahara of Southeast Asia, because they are like two drops of water. You know, anyone who wants to study the issue, the violations of international law by a country, has a formidable case study in the case of Morocco, because there are few rules that the regime of Hassan II and his son Mohammed VI have not violated. A violation of UN Charter, a violation of treaties, violation of almost all human rights, violations of international humanitarian law, including the looting of natural resources and the relocation of its nationals in the occupied territory, non-compliance with signed agreements, violation of the ceasefire, very recent, and so on. Well, if you want just the first illegalities, those committed in 75 with the invasion and the occupation of the territory, I can say that it was in the first place a violation of the UN Charter, the prohibition of use of force. Article 2, paragraph 4 provides that a UN member state cannot threaten or use force against the territorial integrity or political independence of another state. It was also, indeed, as you said, a crime against peace, an act of aggression. I hope that Jeff will arrive to speak about it, because it's indeed a very technical subject. It was first, as you also said, in the first tribunals, Nuremberg Tribunal and Tokyo Tribunal was already referred. I'm sorry, my voice is a little bit strange because I have problems with one tooth, but I hope you understand what I say.
Certainly.
As I said, the crime of aggression was already spoken in these two tribunals, but then later there was a UN resolution with an annex, and the annex was the definition of aggression. And the International Law Commission also spoke very much about this question of the act of aggression, crime of aggression.
Which we'll get to next, because Professor Smith has actually joined us.
Good. Okay. In fact, I'll leave it like that.
Well, no, that's very much appreciated. And Professor Smith, let me just introduce, teaches law and human security at the Norman Patterson School of International Affairs in Ottawa, Canada, and a former counsel to the United Nations mission in East Timor. So I want to welcome him to the program and actually turn directly to you, Jeff, if you don't mind, and ask about this issue of crime of aggression, about which you've written, and explain to the audience, what is this issue of the crime of aggression, and how does this relate to the question of the Western Sahara?
That's well phrased, and thank you to everyone who's joined today. It's great to be connected in with you in such an important topic. Profoundly, the crime of aggression is at work in Western Sahara. There is a kind of 2- or 3-fold manifestation and a relevance of the crime. We talk a great deal about the events of 1975, and at its most fundamental, we can see the crime at work in that history of the illegal, without cause, in violation of the United Nations Charter, as Pedro has pointed out, at work. But the crime persists today. Secondly, it, as crimes do, entails or results in particular personal liability or responsibility of individuals in the Moroccan state. We'll come back to that. You might have a question. But third, there's an aspect of why, well, probably two parts to this third aspect of why aggression is important. It's about the world in which we live, that aggression, the use of armed force without lawful justification, without excuse, without Security Council approval, is meant to be a first protection of the global order, the global political legal order, and with that, human rights in our world. Um, and so that there's a fundamental that's at stake here. But narrowly, and particularly in the case of Western Sahara, the crime of aggression, and I'll explain, or you'll ask a question of me of how it manifests itself, how it currently is taking place, if you will. We'll come to that in a moment. But for Western Sahara, the crime reminds us in a powerful way that there are two bodies of law, two sources of law, which apply to the case of Africa's last colony, to the circumstances of Western Sahara. Both of them flow out of the United Nations Charter as a kind of global constitution. The first, of course, is the right of self-determination, the right of non-self-governing peoples to self-determination. And that has become the framework and the significant discourse, the dialogue or the narrative that has occupied much of the discussion and the treatment of the question of Western Sahara. But the other source of law is international humanitarian law, the law of protecting people, in particular in circumstances of armed conflict. And understanding the crime of aggression reveals the extent to which that law must apply and has tended to be disregarded. So that's a lot there, but those are kind of three overarching frames of why thinking about aggression is important in this contemporary setting.
And we'll come back to that. Thank you. And Sheha, I'd like you to talk with us about what has been the impact of these violations of international law on the Sahrawi people, those in the occupied territories as well as in the refugee camps. If you could make this real in terms of getting beyond just a discussion of, well, what's the impact been?
Thank you very much, Bill. Thanks also to my colleagues and to the audience. Thanks for being here with us and for giving me this opportunity to speak on behalf of my people, which is so much heavy that sometimes I even doubt myself whether am I going to do it correctly or not, because day after day, the violations and the impact those violations have, it just shows that there's something wrong. There's something wrong happening that we should deal with. And the impact, as you mentioned, Bill, it's on the Sahrawis in the refugee camps, on the Sahrawis in the occupied territories, even on the Sahrawis in the diaspora. In the Sahrawis in the occupied territories, you see it, for example, in the impact on the youth, where the Sahrawis, young generations are lost, where you see young kids from school kicked just for drawing the map or singing out loud the songs from traditional songs from the Sahrawis, the Sahrawi culture, from the Sahrawi identity. You see the impact on women. I can't just go by without mentioning Sultana Khaya, without mentioning the rest of women who have been raped, who have been tortured, the way that the Moroccan occupation is using the body of the women to torture not only the woman, but her family, but her tribe, but her people. The way that the Moroccan occupation is dealing with the Sahrawi women as if she had no soul. And we see that with the Sultana Khaya, and we have seen it with many other Sahrawi women, and probably we will see it with many others, as long as the international community is not reacting. We see the impact in the occupied territories also with the natural resources. Western Sahara is nothing but poor. Western Sahara is not poor at all, but you see that the people in Western Sahara, in the occupied territories, are depending on something that's called the card, they call it La Cartilla, with which the Moroccan occupation is trying to control the Sahrawi population, with which that amount of money that's given to you, it depends on how active you are for them. As long as you don't go in manifestations, as long as you're not being active, as long as you're not being defending your cause or the freedom or the independence, you're being fed. Otherwise, You have no other source of living. We see it also on the way the Moroccan occupation, in a dirty way, in a mean way, and a savage even way. They spread the drugs, let's say, the alcohol amongst the young generation. I have had the chance to be with Sahrawi women from the occupied territories that have been telling me stories that they break your heart, where you see that you send your child to the school, but then without you knowing that they are being addicted to certain things that they are having. For example, normal kids, they go and buy from the grocery store. They buy, for example, the bakeries, or they buy something that it has been made, but that thing contains something that actually makes them addict. And then you see that you lose. I have spoke to mothers that they say, I have done nothing bad with my kids. I wanted to raise them properly, but then I received them, I sent them to school, but then I received them addicts. So I feel like the Moroccan occupation is trying to make sure that the Sahrawi generation, the upcoming Sahrawi generation, will be lost. The impact, you see it, as I said, you see it on our families in the refugee camps. I was born in the refugee camps, and I have seen that impact myself. I was born and raised there, and I have seen those impacts. But what the Moroccan occupation doesn't see is that the hardest those impacts are on us, the strongest we become, and the more confident we become. Because let's say, we are not on the same level with the Moroccan occupation, that's true. But they're using their mean and their dirty ways to conquer us, to occupy us, to silence us. And we are using our faith, our love of freedom, and our convincement that that land, that homeland belongs to us. I know I will one day be back to home. I know one day I will be able to breathe that, let's say, free air. But the impacts are, I can even tell you the impacts on the Sahrawis who live in the diaspora. Probably there's this point that if I mention it to you, Bill, and everyone, you will even say, how is it possible that you think about this? Sometimes we fear our parents to die and ourselves to die, because where will we end up? Where will we end up? Because our homeland is occupied. We will be buried in the refugee camps. There will be no rights for our next generation to actually come visit us and put some flowers over our tumbas. I don't know how to say that in English.
Tombs.
Yes, what I want to say is that you have this lack of and this is the other impact that I would like to mention, is that as Sahrawis, the way we see the international community and the role of the United Nations working on Western Sahara, the constant violation by the Moroccan occupation against the Sahrawis, against whether the international law, international humanitarian law, it really makes us seriously question the role of the United Nations. I really sometimes say, what is it there for?
Mm-hmm.
Because for me, the United Nations, especially with the situation of Western Sahara, it's the clear example of the will of solving conflict, because they have all the means to solve the conflict. Pedro have spoke about that. Jeffrey have spoken about that. And many other experts that have spoken about that. If the United Nations wants to solve the conflict right now, they will do it, because they have all the means. Yes.
No. I have to ask you to hold on the point, because I want to keep moving in this discussion. Yeah. And I want to switch gears somewhat. Two of you, Pedro and Jeff, you have been involved in the past, were involved in the situation in East Timor, and which for many of you that are watching this, you may remember how in the 1990s, the situation there blew up. There was genocide being carried out by the Indonesian government. There was international engagement And I'd like you what's the parallel? What do we learn from what happened in East Timor? How does it relate to the Western Sahara? And more specifically, why is the international community not responding to the Western Sahara in the way that it ultimately responded around East Timor? And whoever wants to speak, this is to any of the three of you.
No, I started already. Perhaps I can go on. I said that, if you all remember, that the questions of Western Sahara and East Timor are like two drops of water.
Right.
And why? It started by the fact that the administering powers of the two territories were Portugal and Spain, this outside in the peninsula, Iberia, and the fact as well that they were dictatorships. Portugal had Salazar, and later Caetano, and Spain had Franco, the Generalissimo Franco. The fact that the two colonies, it's true that one was very near Europe, the other on the other side of the world, but they had two neighbors, both ruled by dictators, Hassan II in Morocco and Suharto in Indonesia, who at the moment that there was a chance for these two colonies to become independent, they invaded. And they invaded with a difference of 1 month, something like that. First, it was the case of Western Sahara, then East Timor. And they got the green light from the same person, Henry Kissinger. Of course, the Security Council reacted exactly in the same way. They asked, or they demanded the invaders to leave the territory, and they didn't do it. It was one more violation of international law, because Article 25 of the Charter obliged the states to comply with what the Security Council says. Well, for the rest, so many similarities. All the time, even in the small details, I'm seeing that there are similarities, and well, I think that Jeffrey can say more about this, because he knows also very well the question of Western Sahara.
Please, Jeffrey.
Yeah, I think it's hard to capitalize on that, Pedro. I think for us there are two lessons, if you will, for people concerned. And what's the level of your concern? A sort of global order of rules, the particular case of Western Sahara, self-interest. These things tend to come around. The first is a kind of paradox, the use or reliance on the law. Some of our conversation this evening is about the law. And in many respects, the law is disregarded and can't take us entirely there. The institutions, the levers, the mechanisms are not sufficiently within the control of the peoples most affected. In fact, least of all in many respects, and that would make for an interesting comparative conversation. And yet, on the other hand, and here's the paradox, the law is a substantial, a significant foundation of obligation. It's a great sort of English language word. It's a bulwark. It's undeniable. If you meet someone who contends that Morocco, and occupying Morocco, has a territorial claim to Western Sahara, you can remind them that the law on the point is settled, no less than the International Court of Justice, and somewhat uniquely in decolonization cases or settings, has disposed of the issue or dealt with it. So although the law is not always within our grasp. It's a powerful normative reminder. I think that's the first thing. We must never hold out hope on the law. We must always remind ourselves and others of what the law requires, because there may be elements of self-interest, as it were, or parallel cases that are to be prevented. We can think of the Ukraine, Crimea, and Russia as an easy example. The other thing is that is relevant, I feel, for us today is that every aspect of public witness, solidarity, of work is important. When a tipping point comes, as inevitably it must, and I think, am I allowed to say this? The point is perhaps debatable. The case of Timor-Leste, East Timor, was always more intractable, more fraught, more dire, more entrenched than Western Sahara has ever seemed to be. In the darkest moments of the modern history of Western Sahara, Sahrawi self-determination more properly, they have not been as dark as the case of Timor-Leste. And we came to, my point is that we came to a tipping point in Timor-Leste because of a combination of events that were fostered and nudged along by incremental action in every quarter. There was a comprehensive resistance network of Timorese people who were well organized. There was a global solidarity campaign. The right political moment in the occupying power arrived, and so on and so on. And that is both inspiration and it allows us to search for possibilities.
Thank you. Shah, I want to go back to you for a second. You mentioned in passing the case of Sultana Haya. And unfortunately, many people in the United States have no clue as to who she is and what this case is about. And I'd appreciate if you could just give us a brief summary as to who she is and why this attention to her. What's going on and how does that relate to the law?
So Sultana Haya is a Sahrawi young woman who have been involved since her teenage, let's say, years within the revolution for the independence in Western Sahara. She has been in 2005. One of her eyes was took off by the Moroccan occupation. She has been tortured several times. At this specific time, exactly 1 year ago, when she started revolution throughout her own house with her mother and her sister. They started just going on top of their house with flags and saying "Free Western Sahara." This lady and her mother and her sister have been tortured, have been raped physically by the Moroccan militaries, and also even with objects, has been injected with things that she still, for the moment, she still doesn't know what things were. And she has been through, for more than a year, through a hell of day and night life. And everything was for what? It's just because she goes and she says, "Free Western Sahara, we want the revolution, we want our freedom." So what Sultana is not only one individual. Sultana is all the Sahrawi women. So she knows that. That's why when I listen to her, sometimes I even feel guilty. I even feel like I am nothing in front of this woman. What can I do? Sometimes I swear, I spent sleepless nights just thinking how shame I must feel because I have this great woman and I'm doing nothing for her. Just as much as just sitting and talking in front of the camera. Because I see this woman, I just feel proud. And I see it and I feel it in her voice when she's defending her cause. And you see all these Moroccan occupation militaries in front of her house, all of them with their military equipments, with their cars, all of them just in front of this woman with this flag. They tried to block her house. She broke up the wall of the house so she still could have access on the top of her house, and still trying to make the flag of her country and trying to make that flag just go up in Western Sahara. So Sultana Khaya, I recommend people to go and check on her story, on the power of the voice of a woman from Western Sahara. Because what I see from Sultana is that she has nothing to lose. When you listen to her and when you see her, especially when you directly understand what she's saying, you notice she has nothing to lose. You wanna kill me? Just kill me. But at least I would die defending the right of my people to freedom. That's what I still don't understand, and I would like the professionals to help me understand, is that we have the international law by our side. We have the Hague. We have the United Nations resolutions. We have the European Court of Justice by our side. We, as Pedro said, we are just like two drops, like East Timor. Why the conflict of Western Sahara is still not solved, and why women like Sultana Khaya are still suffering?
Well, that is the question that we need to get to tonight. I mean, there had to build off of your point, there had been since 1975 a series of international law decisions that have gone against Morocco. And I wanted to ask you all to speak some about that. There was Morocco's claim to the territory, which the International Court of Justice said no, they had no such claim. There have been other such examples, and yet none of that seems to put a brake on Moroccan aggression. So what are we to make of that then? What does that mean when we're talking about international law? Jeff?
That's a great question. At risk of being facetious, it means we're all at risk. That when the law is meant to apply to us, if we don't have the leverage of it, the instrumentality, the ability to take it, and the Sahrawi people have through their representative institutions in unique ways, ways that are deeply inspiring in a post-colonial world. We can talk about that, but where we don't have that, we are at risk. International law, of course, is a construct of states, and where states are unwilling to act, we might say a colonial Spain in the case of Western Sahara, that's provocative, or international organizations are unwilling to act in direct application of the law or to conform to what the law so obviously requires. European Union institutions as a current example, then we have problems. I sometimes tell students that in a century or two, we will look back at this as a primitive legal system, one that had gaps in it, that was imperfect. You know, we've come a long way in the modern era. So I call it the era of the UN Charter. But the problem of jurisdiction, who directs and who leads, remains with us. The other thing is, allow me this point, that we in the discourse or the narrative, the conversation, how the international organized community, states and the UN, the European Union, its institutions, regards Western Sahara is stuck or conveniently relegated, conveniently described as being a case of self-determination. And there's lots of very settled law around that. It takes us to very clear places. That is within the purview or the jurisdiction or power in particular of the United Nations. And so what does that mean? It allows all of the rest of us, indeed as individuals who have responsibilities under international law, we do, to avoid or defer. And if you gather the statements of, say, resource companies involved in occupied Western Sahara around the phosphate rock trade, or of governments confronted with some connection with Western Sahara almost invariably you will see this, certainly in global north actors, countries and corporations, that we defer to the role of the United Nations. It's a bit like me saying, I defer to the role of the police as I am witnessing an armed robbery of my neighbor's house and the partial disposition of my neighbor's house and the stealing of their assets. Well, or worse, I must wait for the courts before I can act. It's sort of morally and in leveraging the law, the same thing.
I want to build on this, and there's a question that's been posed in our chat by Ambassador Christopher Ross, which I'd just like to read for each of you to respond to. And it relates to what you were just saying, Jeff. He said, as the Secretary General of the UN's personal envoy for Western Sahara for 8 years, 2009 to 2017, I face Moroccan impunity daily. I ask again, what can those committed to international law do in the face of stakeholders who shut their eyes to this law? And I'd like you, the three of you, you started, Jeff, but I'd like the three of you to respond to this. Sheha, Pedro, I don't know which of you would like to take off on that. And then Jeff.
I think Pedro would have more professional. I would go for from my perspective. Sometimes I feel like Mr. Ross is one of those who should have had the answer at certain point of their career. But now I try also to think wisely and think that he himself and others are going through so much pressure. But what I think is that this pressure that the Moroccan occupation is having, not only, and this manipulation that Mr. Ross knows perfectly what I mean, is not only against him or against us as Sahrawis, it's against everyone who's supporting the international law and supporting the international legality, the realization of the international legality. So the problem here is, what I would consider is that everyone who has the role to at least speak up when they can, at least speak up and say the truth, at least. That means the world for us to recognize that something wrong is being committed and something wrong, but in the moment you are doing your activity, I think.
Thank you. Pedro.
Well, I think I can go back to what we already spoke about, the difference between the treatment of East Timor and Western Sahara, and it answers also to what you asked now, is that there's a struggle always between international law and realpolitik. And that happened, of course, in the case of Western Sahara and in the case of East Timor. But there's a very big difference here. The facts are the same, the law is the same, but we have here two countries who were completely devoted to defend the oppressor, the Indonesia and East Timor, and it was Australia in the case of Indonesia and France in the case of Morocco. Now, it's very clear that Australia is not so important as France and has not a place in the Security Council with veto power. That's one of the things. The other thing is the administering power. Portugal, in the beginning, did incredibly stupid things and allowed, even when they moved the administration to the island of Atauro and created a kind of vacuum in Dili, they in fact allowed the Indonesian to invade. But after some time, Portugal was defending the Sahrawis in all fora. Now Spain, on the opposite, sold the Western Sahara to Morocco and Mauritania, and It doesn't matter if it's the PP or the Socialist Party, they are always completely in the hands of Morocco, and they are subject, of course, to the chantage of Morocco. And the third thing that I find very important, it's, by the way, Professor Stefan Zun said that very often in different articles, and when speaking with me, he told me already several times as well, is that a big difference between the solidarity. The solidarity with East Timor was very well organized, at the coordination, a very important coordination. The case of Western Sahara is not like that. Except in the case of natural resources, the Western Sahara Resource Watch is doing a wonderful job. And in the case of human rights, there's now this Geneva support group, by the way, who is shared by the ambassador of East Timor, to show again the connection between the two causes. But there is no good coordination at the level of the struggle for the right to self-determination and the political aspect. That's a big difference. Mm-hmm. I can tell you, and I notice that very often, that what happens for instance, in South Africa is absolutely not known in Spain, or what happened in the solidarity in the United States is not known in Australia, for instance.
Jeff, I want you to go answer the same question, and then I want to shift gears and ask you all another one. Go ahead, Jeff.
Yeah, it's a question at the kind of at the heart of our engagement. I think there's a couple of things that can be said. We must always remind ourselves, like, this sounds a bit hortatory, it sounds like something you would say in a classroom, but the law is within the reach of all of us. The subject of what international law is and how to apply it must not be obscure. It must not be relegated or the object of anxiety to people, relegated to so-called experts or academics, perhaps most of all. The fundamentals of this global order of peace and security, however imperfect it is with its historical roots and its institutions, are things that concern all of us. Russia, Crimea, Ukraine, as a kind of contemporary example, if you will. But there's lots, but what about specific techniques? There's lots of good reading to be done. Start with the International Court of Justice case, the advisory opinion on Western Sahara. It is surprisingly accessible. It's a powerful read, and it remains significantly relevant. I think the other thing, though, is a very kind of practical matter, is holding out what the law requires of all of us and our governments. It takes surprisingly little to remind institutions and corporations of what their obligations are. The obligation not to contribute to an unlawful occupation, the obligation not to participate in stripping resources out of an occupied Western Sahara. There's lots of available things that are fairly readily understood. And much of that ground, as Pedro has noted, has been established in both cases, but in Western Sahara in recent years.
We have about 10 more minutes, and I wanted to ask you, the three of you, to talk about how does international law relate to the question of the right of self-determination, and particularly for former colonies. Where does this all come together? There's a related question, which is something that's perplexed me. The Moroccans essentially announced in the late 90s that they were no longer going to accept independence as an option. which seems on its face to flaunt self-determination, and that they would only accept annexation or autonomy. When we're looking at this issue of self-determination, these seem to be pretty blatant violations. So am I missing something?
No.
Whoever would like to start.
No. Maybe I'll begin us, and I can sort of fuse or join the two in
Please.
a unique way. The outright answer to your questions, the question of diminishing the available options for a colonized people, non-self-governed people, is a flat no. Well-established international law, and there are few principles of a greater understood importance, of greater normativity, that are universally binding on states and individuals like you and I as also subjected to international law, than the right to self-determination. Very uniquely, the United Nations Charter prescribes that right as a sacred trust. That is powerful wording. It sounds political, it sounds almost rhetorical, but in a constitutional legal instrument that the Charter is, it is remarkable language, and it places the duty very much at the fore of international law's obligations. And the duty, by the way, transcends itself into the leading human rights treaties of our time, the Civil and Political Rights Convention, ICCPR, and the Economic and Social Rights Convention, the ICESCR. Those are Article 1 in each of those two framework conventions for us. So the right is universal and it's powerfully binding in a way. And here's the point for us in law that requires us to positive action to realize the right. I'll give you an example from the country in which I live and work, Canada. As a person subject to international law, do I have to have regard for the years in which Sahrawi, Western Sahara, phosphate rock, 2013 through early 2019, was imported into my country? Essentially, yes, because as a citizen subject to international law, I have an obligation to make good the sacred trust of Article 73 of the UN Convention. But here's the point of fusion, and I'm mindful of time. Guess what? The intentional denial of the right to self-determination, we are not going to let you have the full range of options that the law requires, is itself an individual criminal act, the crime of aggression. The crime of aggression is about unlawful invasion with the use of armed force, occupation, annexation, as we now see in progress. But it also extends to a fourth particular act, because the crime of aggression is a crime defined as against the order established by the UN Charter, self-determination. So denying self-determination in its full manifestation, the option of independence as a choice that's not mine or yours or the international community's, is itself makes out the elements of aggression. And it's an interesting point of fusion that I think we can do things with, but that reminds us of the seriousness of the wrongful, of everything that is wrong in occupied Western Sahara.
Thank you. Shahar, on this question on self-determination.
I think from the Sahrawi perspective, or at least from mine, Jeff said something before. He said, we are all at risk. And I think that sometimes the Sahrawis will see the right to self-determination as a promise from the United Nations. But it's more than that. It's more of our right, and this right. So we live now in a world where I feel like the mean or the oppressors are learning more from each other, more than we, the people who defend our rights, are trying to help each other. So if the right to self-determination of the Sahrawi people falls, this means that many other rights are also going to fall. And this means that Morocco is going to feel much more empowered, and many other oppressing governments that will be much more empowered. And that means, by the end, that the United Nations and its backbone, I'm not going to speak about that subject, will actually have no other sense. So it will be the strongest, not the one who has the right. It will be more the strongest. So I think that the right to self-determination of the Sahrawi people, it's not only for us. It should be defended to prove that the international law has to prevail and has to actually survive over this oppression, that it's not only the Sahrawi's right, but the international law in general.
Thank you.
Suffering.
Pedro, you have the final comment on this.
Well, right to self-determination, as Jeff has said, is the base of all human rights to start with. But the so-called Magna Carta of self-determination, the Resolution 1514, makes it very clear that the self-determination applies to all peoples, and it is the base of so many other rights, in fact, and you see as well that the self-determination was perhaps the first of the cases of jus cogens, or the peremptory norm of international law. It was perhaps even the one of the reasons that the Convention on Treaties was speaking about this cases of jus cogens. But again, there's one thing I would like to be a scientist who is studying the new variants of the corona crisis, because they can come with different positions, and they find new things, while we as lawyers, and particularly in the case of international law, it's very, how can I say, very boring, because everything is clear. The only thing that is not right and is not clear is the position, the realpolitik, the position of stupid governments who side with the oppressors.
On that note, I want to thank each of you very much for joining the program. I approach this subject cynically. I must argue, the subject meaning international law, because I repeatedly see governments around the world flaunt it. They claim, in the case, for example, of Russia's annexation of Crimea, oh, international law has been broken. And then when it comes to the Western Sahara, silence, or worse, militarily supporting the Moroccan occupation. And I think what each of you have pointed to is the necessity for movements, for pressure, for not relying on international law. That international law can be a banner. It can be something that we call upon, but something more is necessary. And I think each of you have called upon the viewers of this program to actually do something. And I want to thank you each for that. And I want to remind the audience, we've been honored to have Shea Abdullahi, a longtime Sahrawi activist and speaker. Dr. Jeffrey Smith teaches law and human security at the Norman Patterson School of International Affairs in Ottawa, Canada. And Pedro Pito Lete, who has been a jurist and former attorney, and both he and Dr. Smith very active in the case of the East Timor, which we've been discussing this evening. I want to thank the audience and remind you of our website, freewesternsahara.org. And I look forward to you joining us again. We're going to aim to have additional webinars in the next 4 to 6 weeks, focusing on other topics. And one, probably the next topic, is going to be on the issue of US policy towards the region. And what I think can be fairly said, described as its hypocrisy. And the question is then, what do we do? But how do we understand it? How do we understand this hypocrisy, and where do we go? And so we'll be looking at that probably in our next program. I want to thank everyone for joining us. I want to thank, of course, the Institute for the Black World 21st Century, without whom this could not have been done, and the Pan-African Unity Dialogue, and you, the listeners and viewers. Thank you very much, and good evening to you all.